22185211. This is Beaumont Hill versus D. Walker. The matter is before the court, set on for a hearing on today's date. The court has received the complaint in this matter that alleges damages in the nature of $759.16, and also court has received a answer from the defendant in this matter. Your appearance for the plaintiff in this matter. For Beaumont Hill. Right. Do I have last name Walker on the Zoom? Okay.
No, they haven't checked me. No one's checked in on Facebook.
All right, the matter was set on at 9:30 this morning, and neither party has appeared. Therefore, the matter will be dismissed at this time. This is case number 21-171326. This is Z Ride Home LLC versus City of Detroit. The matter is before the court, set on for a pretrial conference regarding this matter. Your appearance for Z Ride, please.
Morning, Your Honor. John Betts, attorney of record for plaintiff Z Ride Home.
All right, thank you, Mr. Betts, and good morning to you. Your P number, if you will, for the record, sir.
P24468.
All right, thank you, counsel. For the City of Detroit, your appearance at this time, please.
Good morning, Your Honor. Ben Patterson on behalf of defendant City of Detroit, P85118.
All right, thank you, Mr. Patterson, and good morning to you as well, sir. All right, somebody update me on what's going on here, please.
Well, Your Honor, this is a transportation bill for a lady that was injured in a City of Detroit bus accident. She has her own suit pending in circuit court before Judge Annette Berry. And the dispute, one of the primary disputes anyhow, is whether or not the City of Detroit is liable to provide PIP benefits, or whether National General Insurance is liable to provide benefits. And the attorneys in our case and our district court case have essentially agreed that this dispute as to insurance coverage really ought to go to Judge Berry. So we would like the opportunity, I guess, to try to get her to agree to have my client intervene into her suit and let her decide that issue. I mean, it doesn't make a lot of sense for her to be looking at that issue and for Your Honor to be looking at that same issue in a separate case.
Yeah, Mr. Patterson, sir.
I think that's generally correct. National General is a defendant in this case. I see the counsel for them did not appear. I heard Mr. Betts calling Mr. Abramson. There are two circuit court cases. The earlier case is the CarePoint case that Mr. Betts has. Really, all of the matters should be consolidated there. But I think for your purposes, Your Honor, yes, will be an intervention to get this case into one of the circuit court cases.
Yeah,
and we have filed a cross complaint against National General in one of those cases related to this priority dispute.
And that cross complaint, that's not in front of me, correct?
That is not. If we didn't have an agreement here for intervention, we would be seeking to file one, but I think everybody agrees it makes sense for this to go to the circuit court.
My suggestion, Your Honor, would be to adjourn the pretrial conference 30 days or 45 days to see if our claims can go into Judge Berry's case. If she agrees and that occurs, then we can dismiss our district court case.
All right, that makes sense. All right, having considered everything, I will grant an adjournment of the pretrial finding good cause, particularly where There is a thought that this case should involve intervention into a pre-existing case in the Wayne County Circuit Court. So I'm going to continue the matter over just beyond 30 days, maybe 40 days or so. I think that's going to put us into that first week of
November.
sorry,
November the 7th.
November the 7th will be the next action date regarding this pretrial conference. November the 7th, I'll set it on for 10 o'clock a.m. 11/7, 10 o'clock a.m.
Very good, Your Honor. Thank you.
Thank you, Your Honor.
All right, thank you. Good day to you, gentlemen.
Bye.
All right, the court now calls case number 22-186-252. This is Automobile Club of Michigan versus Jonathan Washington. The matter is before the court set on for a status conference. This is a first hearing regarding this matter. The court notes that there is the complaint in this matter alleges damages in the amount of approximately $6,000. And I received the answer to the complaint in this matter as well. Your appearance at this time for Automobile Club.
Good morning, Your Honor. Navjot Francis, P72322, on behalf of plaintiff's attorney of record.
All right, thank you, Ms. Francis. Good morning to you, ma'am. I'm looking now for Jonathan Washington, or if you're on the Zoom, say something at this time.
Hello, Your Honor. My name is Jonathan Washington.
All right, thank you, Mr. Washington, and good morning to you, sir.
Good morning.
It looks like there's also a Kevin Campbell as a part of this lawsuit as well. And so do I have Mr. Campbell on the Zoom?
Good morning, Your Honor. I'm Kevin Campbell.
All right, thank you, Mr. Campbell, and good morning to you. Now, I see that there is an answer for both Mr. Campbell as well as Mr. Washington. Madam Counsel, did you receive their respective answers to these matters?
I remember seeing Mr. Washington. Just looking, Judge, sorry.
All right, I do have an answer for both. Both are filed on the same date with the court. That is June 20. Well, I should say Mr. Washington's answer was filed on the 22nd of June. Mr. Campbell's act. Yeah, actually, let me get this straight. Both answers were filed on the 28th of June with the court. All right, have the parties had any opportunity to talk about any possibility of resolving this matter, counsel?
I believe we had some phone contact with the defendants, but I have not spoken with them today, Your Honor.
All right, because it looks like what I'm seeing in the in both answers is as it relates to Mr. Campbell, he says I wasn't the driver in the accident. I had insurance on the car. And then regarding Mr. Washington, he's saying that the vehicle had insurance. I don't agree with the amount, and the accident was not my fault. I made a proper left turn, he indicates here. Well, this is a all right. So very well. Those are the various positions that are taken regarding this matter. Why isn't the if there is insurance, why isn't the insurance brought into these matters, Madam Counsel? You know?
I don't believe we have any proof of insurance yet, Your Honor. That was the conversation we had with one of the defendants, and they were going to get back to us, and we have not heard back, Your Honor. So I believe if we open up discovery, maybe if there is any insurance, we can discover it during that time.
All right, very well. All right, so the next step in this process would be the process of discovery. That is where both parties, or all sides, I should indicate, would have the opportunity.
Your
No,
Honor.
no, no. You know I'm gonna give you a chance to talk, but you know if you hear me talking, you know you can't talk. That's like the real wrong time to talk. The next step in this process is for the court to open the process of discovery. That gives the parties respectively to ask, request in a formal way that any information be provided relative to what the other party's pursuit is in this particular case. This is a normal part of the course of civil cases, is that once there's a complaint filed and then there's an answer to the complaint that's filed, then the court sets up a period of discovery where the parties can exchange information. That information could include identifying insurance policies, answering questions as to what specifically happened in the accident, turning over accidents reports, any of the information along those lines is what would happen during the process of discovery. I'm going to set a period of discovery for that exchange to take place. I'm going to set a next date in this matter. That date's going to be just beyond 60 days because I'm allowing a 60-day period of discovery. That date is going to be
Said 60 days. So, no, you want November or December?
middle of November,
Middle of November, November the 15th.
16.
Yeah,
All right, that's going to be 11/16 is going to be the next action date when the parties come back into the Zoom. You will get a notice from the court with that date, and it will be set at 9:45 a.m. 11/16 at 9:45 a.m. You'll get a document that's called a scheduling order. In that document, it will also provide an opportunity for parties to file a motion or motions requesting the court to do something. And if you file that motion, it could be set for hearing on the 16th of November. I will hear the motion so long as you make sure that you give the other side at least 10 days to respond to any written motion in this matter. So I'll be getting that out in the mail in the next couple of days. We come to Mr. Campbell. Mr. Campbell, you had something to say or you had a question, sir? Go right ahead.
Yes, I did tell the Automobile Club of Michigan I had insurance on the car. The situation was that I didn't have my son's name on the insurance policy. He was using my car while he was moving into college. And I was out of town and he was using my car, but the insurance was under my name. And I told them that. That's what I was trying to say after she said that. I did give them that information. The insurance company said something about because his name wasn't on the actual policy, they couldn't cover it, but it was insurance on the car.
All right. Yeah, I think what counsel was saying is that such a discussion was had, but that there was not information regarding the specific insurance company. Counsel, did you receive information regarding which company was insured this vehicle?
I'm just looking through. I'm not sure if I have the specific company, Your Honor.
So that's what will happen over the process of discovery. And of course, that's the secondary issue is whether or not it is a situation that the insurance would cover, given the fact that Mr. Campbell has indicated that they're taking the position that because his son was not named on the policy, that they will not cover it. That's their initial position. It may be that they are still obligated. That will be something that the plaintiff in this matter will have to pursue. For the time being, the matter is set over for the next date. Mr. Campbell, if there's any information that you want from Automobile Club of Michigan, any documents, any reports or anything, you can formally request those documents in writing, and the insurance company is required to send those documents to you as a part of this lawsuit. If you receive documents from them, interrogatories, requests to admit, you have to be careful to make sure that you respond to those items within the time permitted by law. The document will tell you how much time you have, typically 28 days. Responding to those documents are important because if you don't respond, then oftentimes that can result in a default being entered. So make sure that you respond to any documents that are sent to you. All right, so the next date is again the 6th of November 16th, November 16, 2022 at 9:45 a.m. And I'll take another look at this matter at that time. So is
Thank you, Honor.
Mr. Washington, Mr. Campbell, Mr. Washington is your son, is that what it is, sir?
Yes, sir.
All right, very well. All right, so both of your answers are in, and so I'll address these matters the next time that we come together. Mr. Washington, where are you in school at, sir?
Madonna University.
Oh, okay, all right, excellent, excellent, all right. All right, I paid for a lot of college along the way. I've got 4 grown kids, so
Yes, sir.
I wish you well there, and stay focused and get done what you gotta get done. It's not like I learned from paying for those 4 that have graduated. I got 2 young ones, an 8-year-old and an 11-year-old, so I still have to pay a future, so we'll work it out. All the best to you, Mr. Washington. We'll see you on the next day. Good day to you,
All right.
Mr.
Thank you,
Campbell.
Honor.
Thank you.
Thank you.
Just one moment. All right, the board now calls case number 22-187879. This is Resurgent Receivables LLC versus Maria Coleman. The matter is before the court, set on for a hearing, and it may very well be the first hearing regarding this matter. Your appearance at this time, counsel.
Craig Fay, P81401.
Just one moment.
Water.
Just one moment, counsel.
Sure.
Right, I'm looking for Maria Coleman. If you're on the Zoom, please say something at this time.
I'm here.
All right, good morning to you, Ms. Coleman.
Good
All right,
morning.
So, looks like, well, tell me what's going on here, counsel. Because I see something about settlement and payments. Go ahead, sir.
Sure. We didn't receive a copy of Ms. Coleman's answer. So if the answer does indicate that she wants to discuss settlement, maybe we can go into a breakout room and see if we can try to resolve it today.
Yeah, that's what it seems like. So let me go ahead and set that up for the 2 of you. So ma'am, I'm going to give you a notification to go to breakout room number 1, and the attorney's going to be there, and then you can discuss the issue of settlement as to whether or not this can be resolved, because that's what's been submitted to me as an offer to try and settle it with monthly payments. But
Yeah.
again, I'm going to give you the notification to go to the breakout room. There is your notification now. And counsel, I'm sending the same to you, sir.
Sure.
So I join now.
Yes, ma'am.
Thank you.
All right, this is case number 19-167466, Ford Motor Credit Company versus Michelle Sylvia Coley. The matter is before the court. Looks like on objections to a writ of garnishment. Your appearance for Ford Motor Credit. Anyone for Ford Motor Credit? Do I have Michelle Silva Coley on the Zoom? Say something if you're here. All right, no response on that case. I'll come back to it in the end. The court now calls 21-171462 Michigan First Credit Union versus Tanya Fields. The matter is before the court on objections to a writ of garnishment. The record should reflect that the garnishment is in relationship to Infinity Contacts Incorporated, and the garnishment application is based upon a default judgment that was entered in this matter on the 22nd of May, strictly on the 16th of May, 2022. The total judgment amount is $1,435.93. Your appearance for Michigan First Credit Union, please.
Good morning, Your Honor. Wes Sidney on behalf of Michigan First Credit Union, P number 80307.
Councilman, good morning to you, sir. I'm looking for Tanya Fields. If you're on the Zoom, please say something at this time.
Good morning, Your Honor.
Good morning, Ms. Fields. Good day to you. All right, I see that you filed objections to the garnishment. You indicated that the funds or property are exempt from garnishment. What do you mean by that, ma'am?
Yes, I may have read that. So I did go on Michigan Legal and I read some things with a list of exemptions, but it was from income. So right now, I am receiving food assistant benefits, FAP and EBT. I'm low income. And I'm just requesting a reduction or for it to be, you know, I'm unable to pay at this time. Now, from what I know is that they were sending the information prior to it being getting to the court basis. They were sending the information to the wrong address stating to pay $10 a month. I never received that. And then I received the garnishment in August or maybe September at the correct address. So what I'm asking is maybe for some time. And I also have a second garnishment that I did go to court for today with Discover. That was at 10 a.m. So I do have two garnishments at this time, and that will actually put me below my living expenses at this time. So I was trying to see if I can file a reduction or be exempt from this wage garnishment.
All right, so how much is being taken from you under the garnishment with Infinity under this case? Now,
It just started of last week. They're taking $268 bi-weekly.
So okay, you said bi-weekly, is that what you said?
Yes.
Okay. And the other case that you had, that was a garnishment as well?
Yes, with Discover.
Okay.
That's the second garnishment.
Okay, so when you said that $268 was taken, was that taken on behalf of Infinity, or was that split between the garnishments, or do you know?
It just said on my check, it said garnishment 1. So I do believe it's just from Michigan First because they're the ones who made the first wage garnishment.
Gotcha. All right. So did you reach when you said you went to an earlier hearing, what type of agreement did you come up with there, or what happened in that hearing?
Now, what happened with them, I was able to agree to, since that is $4,000 that I do owe Discover, I was able to agree to $100 a month starting on October 7th. So they did deny my wage garnishment and for me to start paying monthly with Discover. So I should receive something in the mail.
So what they did is they suspended the garnishment so that it wouldn't take effect and allowed you to pay.
Correct.
All right,
correct.
All right, Mr. Neal.
Your Honor, just very quickly, we've not received any funds from the garnishment as of yet. We did receive a disclosure. It was half filled out. It does say that there are payments coming. It doesn't indicate any amounts or anything like that. So I am taking taking Ms. Fields' word that there's going to be funds coming, which obviously it's not a huge amount, so that'll reduce the outstanding significantly. I would be happy to enter a payment order of, $50 a month. I think that would clear this up within less than 2 years. And if she's recovers financially and be able to pay more, that would be great. I think that'd be a fair amount to go forward on.
That makes sense to you, Ms. Fields?
Yes, that would be fair to going forward to fix these garnishments, yes.
All right, that makes sense to me, particularly with the other payment plan that you have. So I'll go ahead and set this one up in that way. What I'll find is that the objections are not valid, and I'll release the funds that are withheld at the current time to the plan. And I will suspend the withholding, that is the garnishment. I'm going to suspend that. And then I'm going to note that a partial payment order is going to be entered requiring a payment of $50 per month. And I'll initiate that $50 per month on October 7th. But when do you pay the $100, ma'am?
My next free check will be October 7th after the rent.
All right. All right.
Yes.
So I'm gonna go ahead and set that for October 7th. And of course, you're gonna want to make sure that you keep up with the payments, because the garnishment is just suspended, meaning that if you don't make the voluntary payments, it'll become unsuspended and then be right back in place. So
Yes.
make sure you get that done right away. So I'm going to go ahead and issue those 2 orders. And ma'am, if you will put your email address in the chat, I will have my clerk to email the suspension of the garnishment as well as the partial payment order to you. That way you can take it to your payroll, and that will prevent future garnishments from taking place. You understand?
Okay. Yes. So get that to my payroll, HR.
Yeah. So go ahead and if you can, put your email address in the chat, and then I'll make sure that we get that out to you today. All right. That's going to be my order. I do wish both sides well. Thank you, counsel, in this matter.
Thank you, Your Honor. You have a good morning.
My question. And are we back on resurgent receivables? Mr. Burke, are you there? Are you here on something?
Sorry, Your Honor. Sorry, on 2 different calls at the same time. I apologize. I had a case that was up at 9:30 that settled, and I don't see the defendant here unless she was here before then. I can give you the case number if that helps.
Is that dynamic?
No, it's Beaumont versus Walker.
I hear Judge, you dismissed it.
Oh, I dismissed that case.
Your Honor, I apologize, and I hope you'll accept this. I was on another Zoom call and trying to get to yours too. So if you'd consider.
Let me call the case.
Thank you.
And then we'll on the record.
Thank you.
22-185-211. This is Beaumont Health versus Tequila, I believe it is, Walker. The matter is before the court set on for a hearing on today's date. Counsel, your appearance at this time, sir.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
All right, thank you, Mr. Burke. And good morning to you. As I indicated off the record that the court did enter an order to dismiss on this matter because I thought that no one had appeared regarding this case. I did see you there on the Zoom, but I didn't make a correlation. I understand that there's been some action on this matter, though, sir. Go right ahead.
There is, Your Honor. Two things. If I could apologize to the court, I was stuck on another Zoom. No excuse. I should have been on two devices at the same time. I am here now, and Ms. Walker and I have reached a resolution. She is on a payment plan that she already began, that has already begun, and she did. Next payment of $50 per month is due October 1st. We sent her on October 29th because she does not have email. We mailed her a consent to review and sign to us. We did call her today again, reminding her that there is a court date and that also she had not returned the consent. If you would consider allowing us about 10 days to get that back from her, you will have it to sign. And as I'm repeating myself, she is already actively on a payment agreement, Your Honor.
All right, I will put simply a control date on it in anticipation of documents of resolution. So I'm going to set it over for October the 4th. In anticipation of the documents, the court will set aside the order of dismissal, the same being held for naught in regard to this matter, and will note the file that there has been a resolution and that paperwork is being submitted.
Thank you, Your Honor. Thank you.
Good day to you, sir.
Have a great day.
And regarding the suffix 7879, that's Resurgent versus Maria Coleman. And I know that both sides were in a breakout room and have returned to the courtroom. Welcome back, Ms. Coleman, and welcome back, Mr. Fay.
Thank you.
If you'll update me, sir, on what the status of things are here, sir.
Sure. We were able to discuss in the breakout room, and we did come to a resolution by way of consent judgment. If we can either place the terms on the record and submit the judgment under the 7-day rule, I can go ahead and do that now.
All right, go right ahead, sir.
Sure. So the matter is going to be resolved, a consent judgment for the complaint balance plus the court costs. Ms. Coleman indicated that she's going to be making payments of $40 per month. The first payment of which is due November 1st of 2022, and then they're going to continue on the 1st of each month thereafter.
All right, Ms. Coleman, are those terms agreeable to you, ma'am?
Yes.
All right. All right, well, I will then consider the matter to be settled. It looks like the total judgment for entry, Counselor, do you have a total amount at this time, sir?
Sure. The complaint balance was $937.78. The costs, the filing fee and the service fee combined is $106.66. So the total judgment would be $1,044.44.
All right. And those numbers, you agree with those numbers, ma'am?
Yes.
All right. All right, and so the $40 payment will begin on the 1st of November. And as long as you make the payments, that's how the judgment will be paid off over time. And that would resolve this case. That's what you'd like to do at this time. Is that correct, ma'am?
Yes.
All right, so ma'am, I'm going to ask that Mr. Fay would send that proposed judgment to me with your initials on it. I'm going to ask him to initial it because it's placed on the record in the court. If that document says what we just went over, do you agree with that being initialed by consent and sent to the court, ma'am?
Yes, that's fine.
All right. All right. Based on the terms as set forth, the court will allow the order to be submitted by way of email, and I'll get that signed, and Ms. Coleman will make sure that copy gets sent to you as well with the terms that have been placed on this record.
Thank you.
Thank you. All right. And Counsel, you have the email address, do you?
Yep. Latifah.hunter@36 District Court.
That's correct.
Got it. Perfect. I'll have that over shortly.
Good day to you, Ms. Coleman, and that's a great last name.
I know.
And so I wish you well. We'll get that document out to you right away.
Thank you so much. You both have a good day.
You too. Have a good day, everyone.
Bye-bye.
You said you just happened on dynamic medical. 886. 886. Did you have 886 or you didn't? You might not have had that. I think that one was dismissed. No, I don't think you had. No. I think it was.
Yeah, that's that, yeah. Well, oh, that's not this lady.
That's the young lady.
No, this is one that I got no response on.
Oh, they resolved that. Might be that. They resolved this. This
Now,
one.
which one were you talking?
886, but you didn't have that. It was for dynamic medical supply, but I think it was dismissed. It should be on that sheet I gave you, I think, on that, there it is. I think it's dismissed. 886 is dismissed, right? Yep, it's dismissed. Yeah. 886, right here, I scratched it out, it's dismissed. Yep. Yeah. Yeah.
All right. Thank you very much.